You're listening to Driving Law, a podcast by Kyla Lee about all things related to the rules of the road.
Hello, and welcome to another episode of Driving Law. I am Kyla Lee at Acumen Law, and with me remotely is my co-host, Paul Doroshenko.
Nice to see your face, Kyla.
Yeah.
I missed the office.
Well, maybe you shouldn't leave it.
Well, I got to go on vacation sometime. Although I was conducting hearings this morning, as I do, and one of the adjudicators was giving me grief for conducting hearings on my vacation.
Well, when do I get to go on vacation?
Well, that's the thing. I was sitting there trying to calculate how much time I work in the day when I'm on vacation, and for him, and like I had 2 hearings, so I spent over an hour preparing for each one of those hearings, and then 30 minutes for one hearing and 45 for the other, because the adjudicator let me go on longer. So add that to my daily thing that I have to do for 20 minutes to half an hour for accounting every night. And then answering emails throughout the day and Slack messages. I figure I'd probably 6-hour workday on vacation.
I do not see for that second hearing you did how you spent an hour preparing for that one. That one was so obvious on the face of it.
Yeah, but I told you who the adjudicator was, and despite the fact that it was obvious on the face of it, I had to go through it all, and you never know. There's sometimes you can have something that's so obvious on the face of it. And as you know, everything can change the moment you find out who's on the other end of the phone.
At an hour of prep?
Yeah, there was a lot there. That was all that medical stuff. There was so much to read. I read it all. I read it all.
So do I. I just read it before because I have to prepare all the files.
One of the things that surprised me was in my hearings in the last 2 days, both of the times the police officers had the date wrong on the report to superintendent. Did you see that?
I had one today where the date was wrong on the report and the narrative.
Yeah, like that. I haven't seen it in probably a few years that the date is wrong on the report to superintendent. And then I had 2 in a row.
Yeah.
Off by a day in both cases, sloppy policing. I know the adjudicator's just going to say, "Oh, it's just a typo." So there's only so much you can make with it, except explaining that if the police officer is unreliable about this most important thing, how much other things are they unreliable about, which was significant in that hearing that you just mentioned and the other one. But that was one same thing.
Yep. I find there seems to be, and adjudicators agree with me on this too, there seems to be trends where there's certain issues that happen at the same time for whatever reason. Like I'll get 6 or 7 files in a row where my client said their last drink was 10 minutes ago and the officer doesn't do the correct waiting period. I'm like, why is it all right now? And then the next week it'll be all refusals or all care and control cases, or it's just weird.
How is it that every file, that you have hearings for on one day, they all start at the top of the hour? Everyone, the traffic stop is at 2100 hours or 2200 hours or 100 hours. They're all at the top of the hour. It's a lie because you can look at 100 reports and see that 50 of them will be at the top of the hour. The rest will be rounded off to the 10th minute. And if I was an adjudicator, I would be so cynical about that. But
yeah, but I mean,
or sometimes it does happen that you pull a horse over.
Don't you have, let's see, this is statistically incorrect, but the simple math is a 1 in 60 chance of it being at the top of the hour.
Yeah.
I know statistically that's not.
I know it's right. I'm sure. I know that's wrong, but I understand the principle, and
yeah,
I'm sure we could ask AI to calculate the odds for us, but
there is a probability.
It's
actually probably greater than 1 in 60.
Yeah.
But
it's just so unbelievable. It's police officers, and I know what they're doing, and what they're doing is they're timing it so they can make it all look like a correct timeline.
Just put that second test outside the 15 minutes, and then you don't have to worry if you messed up on mouth alcohol.
Yep. Yeah. You can lie to the tribunal because there's nobody who's ever going to catch you, and nobody's going to check you.
Anyway, speaking of lying, that's a great segue into our first topic today, which is an Ontario Court of Appeal case called Black. Love the name. Love saying it. Black. So
James Bond villain.
How often in your career has Section 13 of the Charter ever come up?
What the heck is Section 13?
Well, that's how often, huh? That is the right not to self-incriminate.
Oh, yeah, okay. I always confuse 13 and 15 by number. So didn't want to didn't want to say
Yep. 15 is
15
your
is
equality
equality. No.
rates. Yeah. So basically what happened in this case is Mr. Black is in a car accident with his friend Mr. Jamal also in the vehicle with him. And the vehicle occupied by Mr. Black and Mr. Jamal departs the scene of the accident. Cyclist is hurt, catastrophic injuries actually. Um, and Mr. Black ends up convicted of the hit and run offense. I think some other offenses too, but the hit and run for the purposes of this. Um, and the issue on appeal was whether or not Mr. Jamal was permissibly cross-examined on his knowledge of Section 13 of the Charter, because ordinarily there is a prohibition. So if a witness testifies and says, oh yeah, my friend Mr. Black was driving, or my friend Mr. Black was not driving and I was driving, there are some circumstances in which you can cross-examine a person on their knowledge of their right to be free from self-incrimination, but the general rule is that you're not permitted to do so because it leaves the jury or the trier of fact with a false impression that a person is more likely to lie when they know that they are protected in their testimony.
So essentially here, the issue was who was the driver? And
Yes.
Mr. Jamal was going to testify about it. And the question was the extent to which you could ask him about his knowledge
Yes.
about
So
the right to be free from self-incrimination.
yeah, Mr. Jamal gave a number of conflicting accounts. At the prelim, he identified the appellant as the driver, Mr. Black, but then he was told about his Section 13 charter rights, and he reversed his testimony and claimed that he was the driver. And at trial, the judge permitted the Crown to cross-examine him on his knowledge of those protections to explore whether his awareness of that motivated him to fabricate a confession to shield his friend Mr. Black.
Change his story
Yeah.
because he found out about it. Okay.
Yeah. And so the Court of Appeals said that this was one of the rare circumstances in which that cross-examination would be permissible, because not just that he had the shift between the prelim testimony internally in the prelim testimony, but also he had previously offered to take the charge for the appellant in order to get into rehab. So in his police statement, he was like, yeah, Mr. Black was driving. And then he was like, well, actually, no, I was driving and I just, I really want to get into rehab. And then he's like, no, actually, Mr. Black was driving, but I'm going to say I'm driving because he's got kids and I want to help him out. So he was all over the place in his police statement. And the fact that he was basically giving an explanation to the police as to why he would offer himself up opened the door to that cross-examination, coupled with the fact that the testimony had changed as soon as he was told that if he was driving and admitted it, um, he wouldn't be, uh, that evidence wouldn't be admissible against him.
That's an unusual set of facts.
Mm-hmm. Yep. But,
What's driving? No, I just said I was driving because I want to go to rehab. I want to go to rehab. Is it okay if I say that I'm driving? Kids. Hey, I don't have any kids and I should be in rehab. I should be the one who says I was driving. He was the one driving, but I should be the one who's, yeah, I think that.
Yeah.
I don't
I mean,
think
I had that case earlier this year where one of the civilians showed up and all of a sudden remembered absolutely nothing. To ostensibly to try and help his friend. At least that's what the judge found.
we have police officers who show up to trial and remember absolutely nothing.
Yeah, but
And there's police officers who show up to trial who remember absolutely nothing and then lie and say that they remember something.
yes. But anyway, this individual was found to be lying by the judge to try and help his friend. And
Blech.
at one point in my cross-examination, I even raised the possibility that he'd lied to the police that his friend was driving when he told the police that because he wanted to protect himself because he was drunk, and he agreed with that. So it can happen. It can happen. Um,
Absolutely.
Yeah. Anyway, so yeah, the court essentially said that that was fine. Now, there's another aspect of Black that I
I
think
should say judges and even lawyers should probably have lived interesting, diverse, and weird lives before they reached office because, you know, I was older, of course, and before I became a lawyer, and you had all sorts of different things that you've come from in your life that allow you to be able to see this as being a potential out drinking with your friends.
yeah, yeah.
Like your drunken friends can come up with all sorts of things
Look, the
after
difference
they drove or after they didn't drive.
I would say that the difference between most criminal lawyers and their clients, not on every offense, but generally, is we didn't get caught. So
No.
we were able to go to law school and become
We
lawyers.
did. We were fast enough talkers that we got out of it, which allowed us later on to go to law school.
I've never talked myself out of trouble with the police. What are you talking about?
Yeah.
Mm,
I often wonder, where they draw the judges from. That they seem to find people who have cannot empathize with the strange circumstances that people find themselves in.
'Cause they're not appointing from the criminal defense bar as much anymore.
No, no, the judges are appointed from the West End of Vancouver or the West End of Toronto or the West End of Montreal, which I assume is usually the nicest spot. In Edmonton, the West End was the nicest spot.
Crown, government, etc. Anyway, so Black, there's a second aspect to it. So he also appealed his sentence because at trial, he had argued that he should have a shorter sentence. I think he'd asked for a CSO, maybe? I don't know. It doesn't matter what he asked for. The judge gave him a very heavy sentence. So he was sentenced to 4 years and 6 months in prison, and he argued that that was demonstrably unfit. It's the highest known penalty for a hit and run causing bodily harm in Canadian law. Highest.
High penalty, I've, seen it much lower, but very often when we're in those circumstances, you end up with a joint submission where everybody's weighed all of those problems with the case without having a trial.
It's not a joint submission after trial, though.
Nope.
So, the Court of Appeals, no, that's a perfectly reasonable sentence. Because when Parliament enacted Bill C-46, they increased the maximum penalty for the hit and run offense from 10 to 14 years. That is telling the courts that this is serious and there need to be more significant penalties than in the past. And so the court affirmed the sentencing judge's determination in light of the new ceiling and set a new range for hit and run offenses where bodily harm ensues of 3 to 5 years.
And that doesn't surprise me. Does it
That's
surprise you?
hefty, though. Ugh. I mean,
Exactly.
Ontario Court of Appeal, it doesn't surprise me. I can't imagine one of my clients getting 3 to 5 years for a hit and run. Oh, although I will say, when you read on past that portion of the judgment to the part where the court says that there were a number of aggravating factors, including that he had prior driving-related convictions, he'd breached a number of court orders, and he had a 6-month-long, prolonged, and calculated attempt to evade responsibility while fully aware of the victim's catastrophic injuries, then you feel a little less sympathetic.
Yeah, I don't know how you characterize that. I mean, how they come to characterize that way. I so I have concerns about it. The courts view any hit and run as an attempt to thwart the justice system and come across very harshly on it. And I try to explain it to clients, and they somehow doesn't register for most of them. But jail is the starting position. The problem, of course, is if you leave the scene of an accident and you get away, you know, your probability of being convicted drops significantly. If there's no reward really for staying, there's just this alternate punishment for leaving, and nobody knows about it. And so, is there a deterrent from people for leaving? No, and unfortunately, there seems to be an encouragement for people to get away because if you get away, probability of them being able to prove the case is much less. So, you've got those clients who got away from it, and you end up getting them they left the scene of an accident, and you end up doing something very, very good for them. Maybe they're not charged in the end. Maybe you keep them from being charged. And the last thing you're never going to tell them, well, the smartest thing you ever did was run. If you'd stayed there, you would have been convicted. If you ran and got caught, you would have been in huge trouble. And you ran and got away, and now look at this. You win the lottery almost for your horrible behavior.
Yeah, it's like the clients who, in between the time of their incident and the time maybe the police are closing in on them, they hop a plane and flee the country, never to come back again.
Yep.
You can't tell them to do that.
Over the course of my career or my life, I mean, I knew people before I was a lawyer who left the country to avoid. I knew one guy who left the country to avoid being prosecuted. Shouldn't have. Disgusted me. But yeah, there are occasions where you're looking at it and people made that decision. And you're like, rational decision. They would have ended up in jail for 15 years in Canada. And they're never going to be extradited from wherever they happen to land.
I had a client leave the country shortly before her trial on an ASD refusal, which, as you know, is one of the easiest cases to win, and the Crown had agreed to obstruct with a discharge. It's like, what are you doing? What?
Well, some people are just so stressed out by the process, and especially if they've got like dual citizenship and they don't have to worry about, they're not going to be extradited for ASD refusal.
Nope.
If she decides to come back in 15 years, can they prove that she proved the substantive case? Probably not. Can they prove that she fled? They may not be able to prove that at that point. And so in those circumstances, you still may have an invite to come back to Canada.
There you go. Anyway, let's move on to the wildfire situation, because there's a driving law aspect to it now. I mean, there's sort of a number of driving law aspects, one of which is that you're no longer allowed to stop on the highway between Penticton and Summerland or Peachland, that highway, that stretch.
Driving through Summerland, yeah.
But also, the BC government, using its powers under the Wildfire Act and the Wildfire Regulation, has banned all off-road vehicles from being used in any of the fire zones.
And you can understand that. The prevalence of things like side-by-sides with exhaust pipes that can start a fire, dig things up, people going there and doing something else that could start a fire.
Accidents on them.
Yeah, but we've also seen, like in Nova Scotia, when they banned people from going into the forest, that was found to be unconstitutional,
But
which
this
surprised me.
This isn't an outright ban on going to the forest, though, right? It's an outright ban on specific types of vehicles in specific areas. And I
Yes.
think that would survive constitutional muster. Especially, because entire towns are burning down right now. I don't know that that was happening in Nova Scotia when that case
Well,
occurred.
that was the concern when they did it, and I thought it was a reasonable limitation because it's going to be a short period of time in Nova Scotia. I was surprised that it was struck down. But of course, we have this now in BC, and like I cannot see anybody bringing a challenge to that, even if they're ticketed for it, even if they're stopped and find themselves in the circumstance where they are allegedly violated the law. Because if you're going to mount a challenge in BC, I think you're facing something substantively different than you are in Nova Scotia, because we are in this situation. This is several years now. We've had, not year after year, but we've had these horrible forest fires. They are terrible for the health of the people. I mean, uh, you have been in the interior. I have been in the interior. I've driven up to the Caribou, up to Prince George, been to Vernon, been all over the place in this weather. In Merritt, I just drove through it the other day, and the forest fire smoke is awful for the health of people. And I think on balance, it's a very easily defendable law.
Uh, yes. Yes, I agree. Although I will say I can see a situation in which there would be a challenge, and that's because of the penalties. because you can get a ticket for it, and the ticket's like, I think, an $1,150 fine, something like that. That's fine, whatever. You can get an administrative sanction, which can be higher, but you can face up to $1 million
Nobody's going to face that. I mean, if you had that, if you were charged
if
with that.
you start a fire.
But of
And
course,
and cost recovery.
the problem is the moment that the government decides to list a fine like that, all some clever lawyer has to do when their client is ticketed is to then run the hypothetical, which we can do now with charter challenges. You can explain all the different circumstances
The
that
reasonable
happen.
hypothetical is no more. Parliament got rid of the reasonable hypothetical in one of the most recent criminal code amendments.
That's not a charter. That won't withstand charter scrutiny.
But I think no, I don't see the $1 million, if your conduct also starts a fire as being ever imposed. But I do see that if you were to bring that challenge, even though the penalty is like potentially sort of outside the realm of somebody's ability to pay and arguably grossly disproportionate, if you start a fire while you're doing the prohibited conduct, I can't see a judge going, this is unconstitutional. The risk the government was concerned about, the public purpose here doesn't justify the ban, even though a fire was started. Like, it's
Yeah,
kind
I mean, you got to think about
of manifested.
we used to have a big sign in this province that said, "Look at this fire this hillside that'd been burnt out by fire, and the person should be hung." And that was like a government sign that we should be hanging people that start forest fires. We take our forest fires very seriously. Which brings me to another forest fire issue I wanted to talk about. I know we have lots of forest fire issues that we could talk about, but whoever said you should use an ASD when there's forest fire smoke around? We know that approved screening devices have these delicate fuel cells in them. And we know that when you are using a approved screening device, it will do a blank test, which is drawing in air from the manifold, drawing in air that's ambient, forest fire smoky air. You're not supposed to blow in cigarette smoke. If it was 4.5 minutes ago that you smoked a cigarette, you're not supposed to blow it in there because of concerns with damage to the fuel cell. There's other concerns that we have. But one has to um, one has to be thinking that using an approved screening device in any of these circumstances where there's forest fire smoke, you're drawing smoke into your lungs, you're blowing smoke into the device. Doing the blank test, it's blowing smoke into the device. Where in the manual does it say that it's been tested and is reliable in circumstances where there's forest fire smoke?
I feel like maybe we should be going somewhere smoky and doing some experiments.
I don't want to wreck my ASD doing it, but I'm deeply concerned about it because, you've got
Those little green dots.
what's that? Yeah,
Old green dot or
our
something.
small Doppler sensor force, but it wouldn't matter because even if we did do it, nobody would accept our evidence because we're lawyers. Um, you can be the world's biggest expert on forest fire smoke and ASDs, but if you're a lawyer, they're not going to accept it. So I just like here we are, a province where we have chronic forest fires, where we have all sorts of people who have chronic breathing difficulties suffering through these forest fires. Stop in Merritt and you wonder how people survive, or Vernon. And then you've got police officers demanding people provide samples in circumstances where they're breathing in forest fire smoke and they're trying to exhale forest fire smoke and they can't even get enough oxygen in their bodies to keep themselves alive in those circumstances. And let alone, what is it doing to the device?
Yep. Yep. I agree.
Never studied. I've never seen anything where it's been studied, and I think the government is negligent for not studying it and hiring somebody independent, not their normal RCMP lab. Get somebody who's independent to study it.
Okay. We need to move on to the ridiculous driver of the week.
Yes.
And this one's a fun one. You found this one. It's older, but we never saw it before, and it's also kind of close to our hearts. Because this is in Ottawa, a person driving a smart car had
True.
yep, it's for 2 and a 20-foot ladder, apparently. Yeah, there was a ladder. I'm guessing on 20 feet. I don't know.
It looks like a 20-foot ladder to me. I don't know. It might have been in the article. I sent it to you.
Yeah, it's not in the article, so we don't know how big the ladder was. So that's our guess. But it's an educated guess considering how many smart cars you own and have owned.
There was a photo. I have 2 right now, and I've sold 1 before, so I've had 3. And we are a law office that happens to have a 20-foot extendable ladder that looks very similar to this one in our office.
Well, don't get any ideas because this driver was stopped by the OPP and issued a ticket for over cargo capacity, improperly loaded vehicle, because there was no way that a ladder that long could have been safely secured in the vehicle that small.
I was hoping it would be on the roof because I thought it would look great when I saw the headline, and I thought, yeah, you could probably safely tie it on there. I mean, it would be some work, but to see the thing hanging out of the back, not even turned sideways and slid up, like hanging out of the back somehow, I don't know, tight.
I think the seat was reclined too, because there's a picture of the interior with like the ladder with some very loose ropes and a bungee cord. So I think it was like attached to the seat. But you look at that setup, that was not gonna stop that ladder from going anywhere.
It's a great one.
Yeah. So yeah. There you go. That's our podcast. If you got an ASD reading that you don't agree with in wildfire smoke, or you tied a ladder in your smart car, you can give us a call at 604-685-8889 or find us online at vancouvercriminallaw.com and tune in next week for another exciting episode of Driving Law.